Yes, Ms. Crawford.
Thank you, my Lord. My Lords, before the short adjournment, I was making some submissions about Section 15, and I'd finished off with looking at the case of Griffiths and the judgment of Mr. Justice Elias. Over the lunch break, the short break, my Lords hopefully have been provided with some material which arises from a discussion which took place earlier between my learned friend and this court relative to guidance. I think was following on a query from my Lord Stevens. The court should, I hope, have been sent the English statutory guidance, plus also the relevant statute in England and the relevant regulations.
Yes.
Perhaps one can start off by just noting, and I do not profess to understand anything about English law, and I'm not saying this is the correct statement of English law, but in the Care Act of 2014, one can look to Part 4 and Section 14, first of all.
If you just give us one moment to...
Sorry, my Lord.
No, not at all. It's just to find it. I think we got links to the legislation in the emails that were sent to us.
You should have, and hopefully this will be correct legislation as well.
Section 78 of the Care Act 2014, is it?
Yes, I was going to actually... It's not Section 14, what's the... No, I'm sorry, I should have taken my Lords... I was doing this too quickly, my Lords. If I could take my Lords to the Care Act and take my Lords to Section 78 of that, which refers to guidance. And my Lords will see, hopefully in subsection 1, the following, that a local authority must act under the general guidance of the Secretary of State in the exercise of functions given it to it by this part or by regulations under this part.
Yes.
So it's not simply shall have regard to, as we can see, it's a mandatory provision. And the relevant guidance is in a document which was updated as recently as September this year. It's a lengthy document in the PDF. It runs to some 750 pages. And I don't expect my Lords to become familiar with that in the last 20 minutes. I certainly have not. But if I could invite my Lords, first of all, to turn on page 645 of the PDF, which should be headed Annex C.
Yes.
And it provides that this annex covers the treatment of income when conducting a financial assessment in all circumstances.
Sorry, I'm sorry, I'm not.
I'm sorry, my Lord. Page 645.
Care and support statutory guidance.
Yes. And it should be a document which was updated, I should say, on the 2nd of September 2022. I think my Lord will find that on page 3 of the PDF.
Page?
3 of the PDF should be or maybe it was page 2. It's page 2, at least in my copy, statutory guidance, care and support statutory guidance, updated 2nd September 20.
Sorry, I don't have a...
Oh, I'm sorry, my Lord.
I have the guidance, but I don't have it. I don't have numbered pages.
Ah, that is not satisfactory.
They are electronic. You can navigate it. It's pages X of 750, you see, 697 and 750, for example.
I must be looking at a different document.
You are.
Are you on the other email, perhaps, David?
Yeah, it's the other.
My Lord.
Two separate emails.
Right.
Yes, my learner junior sent both the link and an attachment, and if my Lord has the email, if my Lord clicks on the attachment, that should provide a PDF.
This is the email timed at 13:35 today.
So I'm looking at the ones that have been put on in our bundles.
Oh. Let's see. I think it's there. Is it not the top document?
Just found it on the internet as the one method of getting to it.
I'm very sorry.
1320. email has two enclosures. Statutory guidance is the second. That's the one I'm looking at.
Yes.
1335, I got it.
Ah, right.
The email looks like this with an attachment to it.
Yes, I can't get into the emails at the moment. Sorry. Right, I've got it now.
And
That's page 3. Page?
The page indicating what the document is, on my copy at least, is page 2, which is headed Statutory Guidance, Care and Support Statutory Guidance. My Lord has it. Excellent. I'm obliged, my Lord. I'm sorry for the
It is
technical
entirely my fault, and I'm sorry.
No,
No,
technology is wonderful.
Taking us to page.
And the next page I was going to invite the court to look at was on page, hopefully, 645, which is headed Annex C,
Yes, thank you.
Treatment of Income. And we can see that this annex covers the treatment of income when conducting a financial assessment in all circumstances. Reading short, the purpose of this annex is to provide local authorities with detailed guidance on how to apply to the Care and Support Charging and Assessment of Resources Regulations 2014 in terms of how to treat different types of income when calculating what a person can afford to contribute to the cost of their eligible care needs. And that's why we also included in the email earlier the 2014 regulations, but I don't think it will be necessary to take my lords to those regulations. The next page I would invite the court to look at in this document is at page, just check my notes, 659. And hopefully my lords will see a phrase with which we're all now very familiar, disability-related expenditure. Paragraph 13 under that heading, where disability-related benefits are taken into account, the local authority should make an assessment and allow the person to keep enough benefit to pay for necessary disability-related expenditure to meet any needs which are not being met by the local authority. And I just paused to observe there that there's reference to necessary disability-related expenditure. And further on in this document, well, paragraph 40 lists a number of items which should be included in assessing disability-related expenditure, noting that the list is not intended to be exhaustive, and that any reasonable additional cost directly related to a person's disability should be included. And my lords can read for themselves the various items which are then listed. And finally, at paragraph 41, and then observe what it said here in the statutory guidance applicable in England, the care plan may be a good starting point for considering what is necessary disability-related expenditure. However, flexibility is needed. What is disability-related expenditure should not be limited to what is necessary for care and support. For example, above-average heating costs should be considered. Now, I just make the observation here that the local authority's assessment in our case did demonstrate flexibility, at least as regards the items relative to footwear and to the bedding costs. And I pause to observe that those two items weren't limited to what is necessary for care and support, but were necessary disability expenditure. But again, in paragraphs 39 through to 41, we have this concept of necessity to meet the disability-related needs. My Lords do have the relevant regulations, but I don't think it's necessary for my purposes to take my Lords to those regulations. They're simply there for completeness.
There is a power for similar guidance to be given, for guidance to be given in Scotland.
There is under Section 5, as my Lord identified, I think, earlier this morning. I'm not aware of any such guidance having been issued in Scotland, nor are those instructing myself.
Okay.
If I'm wrong in that, then I can only apologise. But returning, if I may, to the submissions I was making just before the short adjournment, I'd invited the court to look at the Griffiths case, and Lord Justice Elias, on the same theme of not making comparisons, and I was making submissions about one shouldn't make comparisons, or one doesn't require, I should say, to make comparisons, although I accept that it may be appropriate in certain circumstances. I would also invite the court yet again to turn up the Swansea case, and once again invite the court to look at what Lord Justice Bean had to say in the Court of Appeal. This time at paragraph 20 on pages 706 to 707 of the bundle. And of course, this was a case where one was looking at different types of disability rather than the contrast between disabled and non-disabled. Lord Justice Bean, towards the bottom of page 706, says this: he rejected what he saw as counsel's implicit comparison with the treatment of different disability. Picking up at paragraph 49, no authority was cited to us to support the view that a disabled person who is treated advantageously in consequence of his disability, but not as advantageously as a person with a different disability or different medical history would have been treated, has a valid claim for discrimination under Section 15, subject only to the defence that treatment was a proportionate means of achieving a legitimate aim. If such a claim were valid, it would call into question the terms of pension schemes or insurance contracts which confer increased benefits in respect of disability caused by injury sustained at work, or which make special provision for disability caused by one type of disease. The critical question can be put in this way: whether treatment which confers advantages on a disabled person but would have conferred greater advantages had his disability arisen more suddenly amounts to unfavourable treatment, and his lordship held that it would not. I would respectfully invite this court to transpose that critical question for this case to the facts of this case, and to ask the question whether the charging policy, the charging exercise, and the availability of deducting DRE, which confer advantages on the appellant, but which would have conferred greater advantages had further items claimed as DRE been accepted, whether that amounts to unfavourable treatment within Section 15. And it will come as no surprise to this court to hear me answer that question in this manner, that it does not. And again, I would submit to this court that even framing the question in the way that I have, and as supported by the authorities, yet again perhaps illustrates that, in effect, what this challenge is a rationality challenge to the local authority's decision to not exclude certain listed items. There may be good or there may be bad arguments for that rationality challenge, But in my submission, it does not amount, the Local Authorities Acts do not amount to unlawful disability discrimination under Section 15. Staying, if I may, with the case of Swansea, and this reflects my third chapter of submissions. In my submission, one requires to be careful, as it's put by Lord Carnworth in Swansea, of artificially separating the method of calculation of the benefit and the benefit to which it gave rise. And in that regard, I refer to Lord Carnworth in the Swansea case at page 709, paragraph 28, where he, in the third line, returns, I think, to the questions he posed himself in paragraph 12. And his lordship says this: "It is necessary first to identify the relevant treatment to which the section is to be applied. In this case, it was the award of a pension. There was nothing intrinsically, quotes, unfavourable or disadvantageous about that. By contrast, in the Malcolm case, there was no doubt as to the nature of the disadvantage suffered by the claimant. No one would dispute that eviction as unfavourable. Council's formulation, to my mind, depends on an artificial separation between the method of calculation and the award to which it gave rise. The only basis on which Mr. Williams was entitled to any award at that time was by reason of his disabilities." And so it goes on. So my submission, albeit I readily accept the facts are different from the facts which are before this court, the principle behind what Lord Carnworth says in there is equally applicable, I would submit, to this case. And it requires this court to identify the treatment and not artificially separate that from the method of calculation for that benefit. And it respectfully, it seems to me that the appellant, insofar as I understood his identification of the treatment, that the appellant does seem to have fallen into that error. He seems to identify the treatment as being either the practice, as he describes it, of the local authority regarding DRE, or, as also described in his case, as ignoring DRE. But of course, putting matters that way is itself to ignore that the appellant was able to claim for DRE and indeed was awarded, if that's the right word, certain items as DRE. And in my submission, and perhaps I'm beginning to sound like the broken record here, the fact that the local authority excluded or ignored, in Mr. Daly's words, other items does not mean that there has been unfavourable treatment and disability discrimination under Section 15. And finally, if I may, my fourth broad chapter of submissions in addressing the 2 or 3 questions which are required to be asked and answered under Section 15. I make this submission, that in considering what was reasonable to charge and practicable to pay, the local authority took account of Mr. McCue's assessed needs as a disabled person again, I pause to remind the court about the statutory guidance, at least applicable in England. Glasgow Council took account of Mr McCue's assessed needs as a disabled person, which included meaningful daily activities and community engagement. And also, because we've heard a bit about holidays, also 20 nights of respite care. Mr McCue is entitled to, and indeed gets provided, 20 nights away from his carers, his parents. And having considered those needs as their starting point, they then considered whether there was anything else in consequence of the disability. And as we know, those something else, some things else, were the bedding and the footwear cost. But they excluded the other items because in the exercise of their judgment, they were not discriminating against Mr McCue because of his disability. My Lords may wish to look at, I don't propose to take my Lords to the detailed and lengthy letter from the respondent to the appellant setting out their approach, but it's to be found in the bundle, in the appendix at page 246 and following.
Can you just give me the reference for the 20 nights of respite care?
Yes. Yes, you will find that in the care plan. That's the right way of describing it. Starting at, I think it's page 267. Let me just check that reference. That's not quite right.
That's the 9 till 3 o'clock.
Yeah. Yes, my Lord will find it at page 267 and then going over to page 271 under about 1/3 of the way down, annual support not described above box on page 271.
Yes, thank you very much.
And the actual described as an outcome-based support plan, it commences from my Lord's notes at page 263. As I think I've already submitted earlier, it's a lengthy and detailed document. No doubt compiled by the appropriate professionals. My Lords, I now propose to look briefly at the question of proportionality in the event, and I now know not to use maxims, Latin maxims employed in Scotland, my apologies, in the event that this court finds that there has been unfavourable treatment. In that event, I require to address the court on whether that was proportionate. This court, of course, will be very familiar with the structured approach taken to proportionality so far as discrimination claims are concerned. Under the Equality Act, it bears a startling resemblance to that described by my Lord Reid in Bank Mellet, but the authority for discrimination claims is that of Aster Communities.
Sorry, is that of?
Aster, A-S-T-E-R, Communities. And the paragraph to which I refer is in the speech of Baroness Hale, paragraph 28, at pages 456, 3 to 457.
Isn't the anterior question of whether there's been any findings of fact in the lower courts in relation to proportionality?
Well, I'm bound to accept that, my Lord, and the difficulty, of course, and I can only say this, and as my Lords may have gathered, the arguments which were presented in the courts below were somewhat removed from the arguments which are now being presented. There was, in the pleadings, a reference to Section 15, but I think that's as far as the argument was developed. We do have in the pleadings, however, for the respondent, material indicating why they chose to deduct, and again under reference to the statutory regime. But yes, I accept entirely that we don't have findings, in fact, and just bare pleadings on proportionality. That is a difficulty which I face, and I can only say that that difficulty arises because of the way in which the case was argued at first and indeed second instance. And I can only address proportionality at that relatively high level. No doubt picking up a comment we made earlier in relation to rationality, if matters had been pled in a different way, then no doubt this court and indeed the courts below would have had material from which it could form its own view about proportionality, of course that being a question for the court. So I can perhaps take this briefly, if I may. Looking to the structured approach set out in Asper Communities, I would first submit that in not taking account of the costs for additional activities, if I might describe it that way, that was a proportionate means of meeting an important objective. That objective, I would submit, being the management of public funds for the assessing the need for and provision of social services. Those funds, of course, are limited, and the 1968 Act recognises that a local authority can recover the charges if reasonable to do so, and if it is practicable for the person to pay those. In my submission, it was practicable to expect the appellant to pay for discretionary items from his own funds, and that this was a proportionate response to the need to manage public funds rather than leave that to choices made by persons such as the appellant, which in my submission runs the risk, or could run the risk, of undermining the purpose and intention of sections 87(1) and 1A. My Lords, I think it's proper that I should take the proportionality chapter of my submissions relatively short, but I would refer to what is set out in paragraph 16 of the local authority's case, which my Lords will find at page 79 of the bundle, of the appendix, I should say. Having made those submissions on proportionality, I now propose to turn, if I may, to section 20. As set out in the respondent's case, it's the submission of the respondent that if the court is with the respondent on the section 15 argument, that the section 20 argument effectively falls away. In other words, if there is no unfavourable treatment, it's difficult to see how, nonetheless, the appellant is placed at a substantial disadvantage. But nonetheless, I do propose to make some submissions, if I may, on section 20. I'm obliged to my Lord Reid for identifying the statutory source for the section 20 duty. Having looked at the matter over the short adjournment, it is, so far as I understand matters, section 29(7). As with Section 15, however, it is, of course, necessary to ask certain questions to address whether or not the duty does arise, and if so, whether it's been breached. Paragraph 20 of the Respondent's case sets out, again, I suspect, a familiar test in the case of VC against Secretary of State.
I was just wondering,
Sorry, my Lord.
You're equating the result of Section 15 with the necessary outcome of Section 20, but the tests are somewhat different, aren't they?
It is, I accept that, and that's why I said effectively.
Yeah, there's no comparison in Section 15, whilst there is a comparison in Section 20. And the comparison in Section 20 is with able-bodied people, is that right? Correct. Right. And so there may be no unfavourable treatment if you identify the treatment, but there might be a substantial disadvantage with able-bodied people. Yes.
I said effectively,
Yeah.
but again, the submission I was then going on to make under reference to the three-stage test in VC is you have to start off and ask yourself a number of questions in a similar way that one asks oneself questions under Section 15.
And well, I just want to press you on this.
No.
I mean, do you abide by or do you hold with the submission that the outcome of that there is no less favourable treatment actually determines Section 20? Or are you just saying it's a factor to be taken into account?
I don't say it determines, but on this case, it doesn't determine it necessarily in all cases, but in this case it does. So I'm going to, again, probably end up repeating myself to a large extent in the submissions I make on Section 20. But I accept entirely the language is different, and indeed a comparison is used. But we see in the authorities the court grappling with this idea of unfavourable treatment and disadvantage, and at least in the Employment Appeal Tribunal case to which I made reference before the short adjournment, the case of Cowie, the view was taken that there was little distinction to be drawn between unfavourable treatment and disadvantage, although in that case the tribunal was looking at Section 19, which used, again, slightly different language. So that's why I make the submission. I don't press it as such because, again, I would submit that one still has to go through the three-stage test and ask oneself, first of all, if I may go into the three-stage test, to put the matter into some structure.
I'm awfully sorry.
I know I've lost.
I'm having difficulty.
I'm sorry, my lord. I was trying to clarify my position, if that's the right way of putting it, in relation to the fact that if the court's with me in Section 15, that's an end of the matter with Section 20.
Yes.
I don't accept that. I don't make the submission that's an absolute, but I say it would probably take me a very long way because the concepts, as we see in some of the authorities, of unfavourable treatment and disadvantage are similar. But I do accept it is necessary to proceed when one comes to look at Section 20 to adopt a three-stage test as set out in the case of VC, Victor Charlie.
Yes.
And that, again, I don't think it's necessary to turn up, but that three-stage test is set out at paragraph 147 on page 654. And the first stage is to identify the provision, criterion, or practice, the PCP, which is said to put the disabled person at a substantial disadvantage. The second step is to determine whether the PCP in fact puts disabled persons at a substantial disadvantage. And thirdly, the assessment of whether in the person, the Secretary of State in that case, in our case, Glasgow City Council, took such steps as it was reasonable to take to avoid the disadvantage. Now, I propose, obviously, to address those steps, but I wonder if I might just say a word or two about what is meant by substantial disadvantage. The appellant, in her written case, correctly notes Section 212 of the 2010 Act and the definition of substantial disadvantage as being more than minor or trivial. My Lords will find Section 212, subsection 1 at page 380. But in addition to looking at Section 212, in my submission, we also need to look at Schedule 2 of the 2010 Act, paragraph 2, which my Lords will find at page 383. Mr. Daly took the court through this schedule, I think, earlier this morning. And I would invite the court to look at paragraph 2, subparagraph 5, where it provides being placed at a substantial disadvantage in relation to the exercise of a function means A, if a benefit is or may be conferred on the exercise, of the function, being placed at a substantial disadvantage in relation to the conferment of the benefit. I draw that provision to this court's attention because, as the court is aware, my submission is that the appellant is having a benefit conferred on him in the exercise of a function, that function being the ability to charge under Section 87 of the 1968 Act. And taking account of what would be reasonably practicable for a person to pay. Returning, if I may, to the three stages set out in the VC decision. The first step, the PCP, I would submit, is the charging and the availability of DRE. That, in my submission, is a benefit to be conferred or may be conferred. The appellant argues, I think, that the PCP was that set out in answer 9 of the local authority's pleadings. But in my submission, that is incorrect. The PCP is the practice provision, criterion of provision, applicable more widely. Again, I would submit that, once again, the appellant is conflating the means and turning that into the PCP. Sorry, that's not the right way to put it. Start again. Insofar as the applicant complains about the manner in which his claim DRE was excluded in the application of the charging policy, that again, my submission falls into the same errors I would submit arise on the part of the appellant in the identification of relevant treatment, in that he seeks to separate the calculation of his DRE from the PCP, which permits DRE to be taken into account in the first place.
Well, I thought the argument was that if you compare the policy or criteria as between an able-bodied person and a disabled person, the able-bodied person doesn't have to have additional costs of somebody accompanying him. And this particular provision, therefore, works is the disabled person is a substantial disadvantage, because under the criteria that you apply, you can't get those sort of costs of a person accompanying the disabled person. So when he goes out in the evening, or when he goes to some function or to a music event, he's got to pay for somebody to accompany him. And so that's what I understood the argument to be.
My Lord may be right, and that takes us back to what we mean by DRE. It's not a term of art. We see it in the guidance. I would submit, and I think I've already submitted, that when one looks to what is meant by DRE, so as not to place somebody at a substantial disadvantage, the concept is whether that's necessary to meet the needs of your disability, as opposed to something which you choose to undertake. You don't need, as a result of your disability, to go to the snooker club, and therefore you don't need to take
well, you certainly,
a supporter with you.
It might be argued that you need somebody to accompany you if you go to a music event.
That doesn't, I can only make the submission, my Lord, and I can only say the submission, I'm not sure I can advance it much further forward. That does not, and I'm using the language of section 15, arise in consequence of disability.
I'm sorry, I'm
sorry,
having real difficulty in hearing.
I'm sorry, my Lord.
I'm losing the point.
I would say in relation to the snooker club that the submission I've been making is that one is looking to disability-related expenditure, which is not a term of art, but that the concept is that is something which is meant to meet the needs of being disabled. And I would submit that going to a snooker club is not something which you need as a disabled person. Or not necessarily. No doubt there may be cases where you do need to go to a snooker club. But the appellant's activities are catered for through the support plan. He has meaningful daily activities. And if he doesn't need, as a result of a disability, to go to the snooker club, he doesn't need, or there is no need, I should say, to have a carer to accompany him. That is not putting him at a disadvantage compared with an able-bodied person.
And how does that compare then to the able-bodied? So the able-bodied is able to go off to a snooker club or indulge in whatever, any activity they want to. And is the disabled at a substantial disadvantage insofar as that freedom of choice to decide what you want to do, to live independently, is removed from you because you can't get the money to pay for it?
Well, that's the able-bodied person would, of course, have to pay for the snooker club. That would,
yes,
yeah.
But he wouldn't have to pay for having an accompanying adult. I mean, I can't see the logic of why, if there's adequate provision in the support plan for activities, that there has to be, that in some way the local authority's got to pay for additional activities that aren't in the support plan. But the able-bodied person is able to go as he wishes out without having the cost of having somebody accompanying him. And isn't that placing the disabled at a substantial disadvantage?
Well, again, one first of all has to identify what is the policy provision or practice, the PCP. And that's why I took my Lords to paragraph 2 of Schedule 2. I would say that PCP is a benefit, and that the appellant in this case is not at a substantial disadvantage in having conferred on the benefit of that policy and the availability of DRE. And it's a similar concept, although I accept entirely Section 20 is looking for something different. But one's not looking for being placed at an advantage compared to anybody else. It's whether, looking at the matter, the disabled person, in fact, is placed at substantial disadvantage, I should say, in having available to him the benefit of the policy and the availability of DRE. And it may be that this case is resolved upon what my Lord's DRE is not a term of art. And this is why it's so, in my submission, fundamental to, first of all, identify what the PCP is, rather than simply saying, well, I could be better off because I could have got money for X, Y, or Z. One has to tie that in to what under Section 15 the treatment is, or what under Section 20 the PCP is. Now, again, if I'm wrong on the first and second steps of that three-stage test, in answering the third step, my submission is that the local authority has taken such steps as are reasonable to avoid the disadvantage. And in that regard, the submission is that the extra items sought by the appellant are not, in fact, reasonable adjustments because the amount is seeking to exclude items representing discretionary spending and further respite care.
The misconception seems to me at the moment is that the is thinking that the legislation is designed to eliminate the disadvantages resulting from disability. Obviously, people suffer disadvantages from disability. Under the 1968 Act, the local authority can provide them with services that they need, but the starting point is they have to pay for those services.
Correct.
If they haven't got the means to pay for them, then to the extent that they can't afford it, they don't have to pay. But if they can, then they have to.
Indeed.
And then when you go to Schedule 2, paragraph 2.5 we're looking at.
Yes, let me just turn it.
Then the function, in the place of the suggested disadvantage in relation to the exercise of a function. Well, the function, whether you regard it as the provision of the services, the care services by a local authority, or it's the recovery of a cost by the care.
Indeed.
Whichever it is, it's confined to the disabled. There is no comparator under Schedule 2.
Par 2.5.
Section 20, subsection 3.
I mean, a public function is one that only applies to disabled people.
So far as this PCP is concerned, if that's said to be the DRE, yes.
Yeah.
Section 20, subsection 3 is the basic provision that requires there to be a comparison, page 374.
Yes. And so there is no comparison with an able-bodied person.
Because they're not entitled to DRE, yes.
Yeah.
Well, they're not entitled to support either.
Yeah, if they don't get the services, there's no question of it being charged.
Well, an able person could be charged for other Section 12A services. You don't have to be disabled to be found in need.
and
Yes,
give me an
but
example of that.
but if the thinking is this all has to make up for a disability, then one can see that's wrong.
The particular paragraph which is challenged by my learned friend is all to do with disability in the charging policy. The charging policy clearly doesn't just apply in relation to those who are disabled.
No. No, but I mean, it's just your misfortune if an able-bodied person can go to a snooker club unaccompanied, but a disabled person, because of the nature of disability, needs to be accompanied. Obviously, that costs some money as well as anything else. But so what in terms of this legislation? I mean, unless it affects your means to the extent that you can't afford to pay for services, which just takes us back to Section 87.
That is, if I may say so, my Lord, the thrust of the respondent's case and the submissions I've been attempting to make in advance today.
Yeah.
Although it's not sure the local authority would thank me for saying so what, because they do like to act in a responsible way.
Yes, but I mean, I don't want to sound uncaring, but the question is legally, so what?
I would tend to agree with my Lord, yes. And as I say, it does support, that thinking does support, as I say, the thrust of the respondent's case and the submissions.
I mean, obviously, what they have to pay for depends on a whole variety of things. Their energy bills, for example, what income they happen to have.
Indeed, people make choices in life, and some of those will be discretionary choices, some of those are something arising out of need. I'm aware that I'm moving away from the microphones again. But it goes back in my submission to the proposition I outlined at the start of my submissions, in that did the local authority, when assessing what was reasonably practicable for Mr. McCue to pay, did they treat him unfavourably or subject him to substantial disadvantage? To which I say the answer is no. Now, one can well see at the margins there might be questions of rationality, but that's not what this case is about.
And so then looking at Section 20, subsection 3, what do you say is the relevant matter?
In relation to a relevant matter?
Yes.
That is determining under Section 78 what is a reasonably practical amount to pay.
Sorry, you said 78. Do you mean 87?
87, I beg my Lord's pardon. Yes, of course I meant 87. I'm conscious of the time. I think I'm almost up to my...
I think we're going round in circles.
We are, indeed. My Lords, I was going to say a word or two about the Cornwall Council case, but in my submission, it's simply an example of fact-sensitive application of what in that case was or was not DRE. I don't think it provides any authoritative sets of principles which the court could apply in looking to this case. So unless there are any other matters I could assist this court on, I renew the motion to refuse the appeal.
Can I just ask about the interaction of Section 20, subsection 3 and Section 87, 1 and 1A? So, as I understand what you were saying just now, Section 87, 1 and 1A will apply potentially to a range of services provided by local authorities, not necessarily just to disabled people. But the local authority will generally have a discretion in relation to all those services to make a charge, subject to the constraints in subsection 1A. So, I mean, do you say this, that if the DRE is just being used as a marker or one indication which indicates whether it is reasonably practicable or not for someone to make a payment out of a certain part of their income, that will be true both in relation to disabled people who may be able to point to their disability and say, well, that imposes particular costs on me, but will also be true in relation to non-disabled people who may have other constraints on their income, but the basic test remains the same. So against that background, and maybe you did put it this way, but I'm not sure that I noted it down, do you say that the provision criterion or practice, assuming, and I suppose it would be a provision criterion or practice of the local authority because it has a discretion whether to make a charge or not, whether that PCP puts a disabled person at a substantial disadvantage, in effect, they're on, I don't know, a level playing field with everyone else. It's just that they have different constraints on their income, which will be taken into account. Other people will have other constraints on their income.
That was the point I was trying to articulate, and perhaps level playing field is a useful phrase.
Yeah.
All right. Okay. Thank you. I just wanted to clarify that.
I suppose other people also, for example, go on holiday. And whether you choose, it's your choice whether you choose to go to, or where you choose to go, and how expensive a holiday you choose to have, and how many people you take with you.
Indeed. I suppose you might want to take grandparents to help with childcare.
Or children. Yeah.
Okay.
Right, thank you.
Oh, thank you.
Well, Mr. Daly.
Thank you, my lords. I shall be very brief. There was a point, I think it was my Lord Burrows that had asked how was the calculation of Andrew going on holiday calculated, and that was at EF 179. And just simply to come back on that, to say it was calculated, and actually there's a narrative that's explained by Mrs. McCue saying annual family holiday, since Andrew cannot travel alone nor be left alone at home, therefore if Andrew was not included in this holiday, then my husband and myself would not be able to have a holiday. Then what they've done is they've apportioned an element of that on a weekly basis with respect to that cost. So they've tried to extrapolate that in relation to arising in relation to Andrew. Could I ask my lords to look at EF page 271? Because my learned friend had referred to the support plan. And I do think it's instructive, and I'm going to come to my Lord President Reid's point about the so what question, and if I can address the so what question, but I think this is relevant. If we look halfway down that page, we see, yes, there's the 30 hours per week care, and yes, there is, as my learned friend had said, this 20 nights short breaks, and then we have additional information. So Andrew's, in the additional information, Andrew's family supports him to attend and privately fund numerous private clubs and activities in the evenings, weekends, and then there are in references them off in terms of the particular clubs, including disabled sports sessions. So what I would say to that is there's a recognition and a cognizance by the respondent that as part of the care and needs that Andrew has as a young person in his 20s, he does have to engage to have an independent life in socialising, to meet other people and to have a basic standard of life. So what I would submit is that the respondents acknowledge that. And I think it's instructive if we come back to the statutory guidance that exists for England, that there's a recognition in that guidance. And I'm thinking, I think my learned friend had taken the court to page 659 of 750. And this is where we see the guidance providing, the statutory guidance in England providing where disability-related benefits are taken into account, the local authority should make an assessment and allow the person to keep enough benefit to pay for necessary disability-related expenditure to meet any needs which are not being met by the local authority. So I say to that the guidance in England is clearly anticipating that there's additional things that have to be met because of disabilities that the local authority is not meeting, and that one should leave enough of social security to benefits to enable a disabled person to meet that. And I read so paragraph 40 makes reference to reasonable additional costs, and I think I'd certainly in my submission fully accepted that any DRE has to be reasonable, and certainly the English statutory guidance clearly makes provision for that.
But I think that reference was made to paragraph 39, which is the introduction to this whole section, where the focus is on keeping enough benefit to pay for necessary disability-related expenditure and things which are required to meet needs not being met by the local authority. So, I mean, I know this case isn't about this, the English guidance, but there does seem to be implicit in that a distinction between things that need to be addressed and, for want of a better term, discretionary spending, where it's not a need, it'd be nice to do it, but you don't have to.
But my Lord says that's why I'd referred the court to EF 271, because the council, in its outcome-based support plan, clearly recognises that there is this additional element to the care that is being provided to Andrew.
Yes, but I mean that doesn't say it's necessary in the sense I've just been debating with you.
No, but I think in my submission I've tried to develop a position which is that it's a reasonable. So the proposition is it's a reasonable thing that arises in relation to having an independent life.
Isn't that a Wednesbury challenge?
I think, my Lord, it could be, but clearly this appeal is not making such a challenge.
And if it were, you would find yourself, for example, having to consider a recipient of services under Section 87 who might, for example, be a single mother with several children. And she has problems going out at night unless she can pay for a babysitter, and therefore having a social life. If she wants to go on holiday, that's going to be very expensive because again, she either takes all the children with her or she finds people to care for them. I mean, in terms of Section 87, we can't just focus on disability.
I fully accept, my Lord President, it is entirely correct. In terms of Section 87, it's much wider. But in my submission, what's happened in this particular case is that the Second Division of the Court of Session has taken a very narrow, restrictive interpretation of Section 87 in relation to disability and the facts of this case, which I would argue was an error of law. And I also say that equally so, that the Second Division has applied the wrong approaches in law in relation to the 2010 Act. And with respect, and to reply to the proposition that the Respondent has advanced this afternoon, which is that Mr McCue is effectively asking for more generous treatment, more benefits as a disabled person, I would respectfully refute that is what's happening here. What the appellant has been arguing today is that the Second Division applied the wrong tests. It wrongly excluded the possibility of categories of DRE on the basis it was considered to be irrelevant. And it took that approach because it followed the Respondent's approach. And that approach, and I think this is the nub of my point, if I may say so, is it took that approach by misdirecting the legal implications of one, Section 87 of the 1968 Act, and two, the statutory duties in terms of Section 15 and 20. And I accept, I'm obliged to my Lord President read Section 29 as the ultimate source of the duty. So I accept that Section 29, subsection 7. And so what I say is that the Inner House got that wrong. And because of that, there was effectively no consideration of particular examples of DRE. And to talk about DRE being discretionary, again, with respect, I think that's a red herring, because one looks at the English statutory guidance, and I think that gives the correct steer. I also think that the cause-like guidance gives the correct steer. And what I've tried to develop today is that the difficulty is that the Respondent's policy itself is entirely terse. I mean, it's a one line, but it's the practice, it's the PCP in terms of how they'll go about treating DRE, which is so flawed and which has been endorsed by the Second Division. So that's been my attempt to challenge that. I think that probably, unless I can assist the court, that would be my reply.
Could you just remind me of the section which actually sets out the, identifies all those persons for whom the local authority has a duty or a power to provide or secure the provision of community care services?
Yes, that's section 12. I'll just simply...
It's section 12, is it?
I think it's... You got it there? It's in the volume 1, tab 1, and it's 12A, I beg your pardon, section 12A, EF 358.
I think possibly you have to go back to section 12.
No, section 12 and then section 12A. Yeah.
And where do we find section 12?
I don't think we've actually...
Okay, but it's in section 12 anyway.
Yes, I've done. Yeah.
it introduces the concept of any relevant person and tells us that a relevant person is someone of not less than 18 years of age who is in need, requiring assistance in kind or in exceptional circumstances in cash. And then the section goes on to provide, or it excludes certain immigrants unless destitute.
I think, my lords, Section 12 is often referred to as the, sort of the general social welfare duty.
Yeah.
So it's a real catch-all of a safety net.
Yes. And it includes at the end persons in need of care and attention arising out of drug or alcohol dependence or release from prison or other form of detention. So it is persons who are in need.
Indeed.
Financial assistance, really.
Yes. I'm obliged.
Any questions? Well, thank you very much, Mr. Daly. Well, we're very grateful to you both for your submissions, and we'll provide you with a judgment as soon as we can.